Basic facts about the African Court on Human and People's Rights. The African Court on Human and People's Rights is a continental court established by member states of the African Union to enhance the protection of human and people's rights in Africa. The court was established by virtue of Article 1 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights. The protocol was adopted on the 9th of June 1998 in Burkina Faso and came into force on the 25th of January 2004. The court then started its operations officially in Addis Ababa, Ethiopia in November 2006. In August 2007, the court moved to its permanent seat in Arusha, Tanzania. Between 2006 and 2008, the court dealt principally with operational and administrative issues, including the development of the structure of the court's registry, preparation of its budget, and drafting of its interim rules of procedure. The court was established to complement and reinforce the protective mandate of the African Commission on Human and People's Rights, often referred to as Banjul Commission. The mission of the court is to enhance the protective mandate of the African Commission on Human and People's Rights by strengthening the human rights protection system in Africa and ensuring respect for and compliance with the African Charter on Human and People's Rights, as well as other international human rights instruments through judicial decisions. The vision of the court is an Africa with a viable human rights culture. Core values. The court bases its core values on the African Charter and other internationally recognized principles of human rights and the promotion of the rule of law. The court continues to foster and uphold the following core values: judicial independence from any partisanship, bias, influence, whether it comes from states, NGOs, funding agencies, or individuals. Fair and impartial application and interpretation of the provisions of the African Charter, the Protocol, the rules, and other relevant international human rights instruments. Transparent and ethical accountability in the operations of the court. Fundamental rights of every individual to enjoy basic civil, political, social, economic, and cultural rights are upheld. Collaboration with relevant stakeholders in pursuance of the court's objective of protecting human and people's rights. Non-discrimination and equality in performance of the work of the court. Integrity of the judges and staff working at the court. Provide equal access to all potential users of the court. Be responsive to the needs of those who approach the court.
Since the adoption of the Protocol in 1998, only 32 of the 55 member states of the African Union have ratified the Protocol. The states are Algeria, Benin, Burkina Faso, Burundi, Cameroon, Chad, Côte d'Ivoire, Comoros, Congo, Democratic Republic of Congo, Gabon, Gambia, Ghana, Guinea-Bissau, Kenya, Libya, Lesotho, Malawi, Mali, Mauritania, Mauritius, Mozambique, Nigeria, Niger, Uganda, Rwanda, Sahrawi Arab Democratic Republic, Senegal, South Africa, Tanzania, Togo, and Tunisia.
In addition to the ratification of the protocol, states have to make declaration required under Article 34(6) of the protocol to allow its citizens to bring cases directly before the court. Without such a declaration, the court would have no jurisdiction over cases brought by individuals and NGOs. The countries which have made the declarations by November 2021 are Burkina Faso, Gambia, Ghana, Guinea-Bissau, Malawi, Mali, Niger, and Tunisia. The court is composed of 11 judges, nationals of member states of the African Union. The current judges are Imani Daud Aboud, President, Tanzania; Blaise Chikaya, Vice President, Republic of Congo; Ben Kioko, Kenya; Rafa Ben Anchour, Tunisia; Ntiam Ondo Menge, Cameroon; Tujilani Rose Chizumila, Malawi; Marie-Thérèse Mukamulisa, Rwanda; Bensaoula Chefika, Algeria; Stella Anukam, Nigeria; Dumitsa Nsebeza, South Africa; and Sako Modibo, Mali. The judges are elected by the Assembly of Heads of State and the Government of the African Union for a period of 6 years and may be re-elected only once. These judges are elected after nomination by their respective states. This is done in their individual capacities, from among African jurists of proven integrity and of recognized practical, judicial, or academic competence and experience in the field of human and people's rights. The judges elect a president and a vice president from among themselves who serve a 2-year term. They can only be re-elected once. The president of the court resides and works on a full-time basis at the seat of the Court of Arusha, Tanzania, while the other 10 judges work on a part-time basis. Working close to the judges to discharge its mandate, namely the protection of human rights to the African people, this office is headed by Registrar, currently Dr. Robertino, a national of Cameroon. He is assisted by the Deputy Registrar, who is currently Mr. Nauho Madani Diallo, a national of Burkina Faso. The court has 2 jurisdictions, and that is contentious and advisory. Under the contentious jurisdiction, which is provided for under Article 3 of the Protocol, the court exercises contentious jurisdictions over all cases and disputes submitted to it concerning the interpretation and application of the African Charter on Human and People's Rights, the Protocol, and any other relevant human rights instrument ratified by the states concerned. Under the advisory jurisdiction, which is provided for under Article 4 of the Protocol, the Court may, at the request of a member state of the African Union (AU), or any of the organs of the African Union, or any African organization recognized by the African Union, provide an opinion on any legal matter relating to the Charter or to any other relevant human rights instruments, provided that the subject matter of the opinion is not related to a matter being examined by the Commission. All applications submitted to the court after exhausting local remedies must comply with the following 7 admissibility requirements provided for under Article 56 of the African Charter, and that is, they must disclose the identity of the applicant, even where the applicant has requested anonymity. They must comply with the Constitutive Act of the African Union and the Charter. They must not be written in any disparaging or insulting language. They must not be based exclusively on news disseminated through the mass media. They must be filed after exhausting local remedies, if any, unless it is obvious that this procedure is unduly prolonged. They must be submitted within a reasonable period of time from the time local remedies are exhausted or from the date the Commission is seized for the matter. And finally, they must not raise cases which have been settled by those states involved in accordance with the principles of the Charter of the United Nations, or the Charter of the Organization of African Unity, or the provisions of the present Charter.
The official languages of the court are English, French, Arabic, and Portuguese. The court may receive applications written in any other African language.